slide.
That's fine.
Well, I thought some of the things you were reading I couldn't see on the slide. That's why.
No, they're on the slide, Chair.
Uh,
Slide 53.
or maybe this one that I was looking at.
No, they're the same.
Okay.
Okay, on slide, if you repeat.
You haven't got something to show us exactly where it is.
We tried that, Chair, and
The TV doesn't allow my pointing.
yes, I understand there is something about white light, so the pointer will not be able to.
Okay, all right.
work on the
Well, you
screen.
can just do the best you can
Okay,
to tell me.
on the top, Chair,
Yeah.
the title says Negotiations Baseline Worksheet
Yes,
Price.
yes.
And
So before we go on, you stated that there were a number of these worksheets
correct.
dealing with different topics.
Different topics, as is apparent from page,
5148
51.
you indicated.
yes.
So did these worksheets reflect Transnet's agreed to negotiating position?
Can you just clarify that aspect, Chair? Because these documents, we received them from Transnet when we're conducting our investigations.
Yes.
And obviously as well, when we had interviews with Mr. Gianni, amongst others, he confirmed that indeed people had mandates. But it turned out later, after the production of our report, that this, as Mr. Gianni said, was just a draft document to guide the team. In our interview as well with Mr. Lahe, and he confirmed in writing that this is the only document that was provided to them to guide them in negotiation. So it is then, now we know this was a document, albeit it being written draft on a document, but it was at least the document that was used as a guide to those who were negotiating.
So as far as these negotiating worksheets are concerned, you would like us now to consider the worksheet dealing with batch pricing,
The one dealing with batch pricing.
which is what we have at your slide 53, volume 3, page 5147.
Correct, yeah.
Okay, then you can take us through the detail.
All right. So you'll see on that one, Chair, it says negotiation point. The concept
in
then
the
is
first column.
First column,
Okay.
on the left, negotiation point, and on the right, it says batch pricing. So that's, now we know this specific worksheet deals with batch pricing. And it then stipulates,
And a negotiation point basically means negotiation item.
and
This
so
is
that's
not a point where they stand on a particular issue. It's just a negotiation item.
it's a negotiation item. I think that's the better phraseology.
Yeah.
Yes, Chair.
It's a negotiation item. And the current offer, because now this reflects what is on offer, says price changes based upon quantity ordered. Right?
Now, on that current offer, it is what is offered by the bidders.
That's what the document
Okay.
signifies. Now, the negotiation issues. So what is it that you must negotiate? The drafter of this document says, the price remains fixed as if order is placed for full 599 or for 599 for the electric or 465 for diesel. So now we know this is what the team must note. Now, what is important here is the comment, the column after comments. It gives the team.
Well, just to go back, negotiation issues. You know, we said negotiation item earlier on. Now they say negotiation issues. But actually, don't they mean Transnet's negotiation point there to say this is where we are, we stand, this is our position?
That's, I think that, Chair, you are quite correct. That's how we understood
Yes.
the issue, to say this is the position that Transnet adopts
Yes.
on this particular item, being
exactly.
batch pricing. So that's how
Yes, yeah.
all these worksheets must be understood.
Yes, yeah, they just got their terms mixed up a bit.
Correct.
Okay, all right.
Now, after comments is blank, the terms at the bottom, it gives you ranges. What is the most desirable outcome? What's the least acceptable agreement and what's the target agreement if you go from first, second, and third column. Because remember, this is a negotiation, so it might be, and this point will come more clearer if you look at other points to indicate the ranges, to say, what is the most desirable outcome? What's the most least acceptable agreement? And what's the target agreement? You'll see on this one, under all items, is remove batch pricing. So the most desirable outcome, remove batch pricing. The least acceptable agreement, remove batch pricing. Target agreement, remove batch pricing. There's no change in terms of what is the scope that you give to the team. And this is consistent.
Chair, if
Well, I think what gives rise to confusion is the dividing line between the horizontal column where you have most desirable outcome, least acceptable agreement, and target agreement. The dividing line creates the impression that where it says remove batch pricing is enjoys the same status as comments, negotiation issues, current offer, whereas from what you are saying, it seems to me that that dividing line shouldn't be there, and remove batch pricing, remove batch pricing, remove batch pricing under different headings all falls under the column that has most desirable outcome. Well, what it means is that the most desirable outcome is the removal of batch pricing.
Correct, because that color is gray in
Yes.
color is.
And the least acceptable agreement, but that doesn't make sense, does it?
Chair, may I? If we
Yeah.
go to volume 3, page 5147,
Yes.
what you have at slide 53 is an attempt to uplift that table in its entirety. I think perhaps technology got the better of Mr. Sidumedi and didn't quite work out. It is better understandable at 5147, and the chair can see the various options, outcome options that are considered,
Oh, yes.
and the position adopted by Transnet in each instance, which is remove batch pricing.
Yes, yes, but on my 5147, there is no remove batch pricing under most desirable. Is that right?
I am at,
At 5147, are we on the same page?
apologies, Chair, you swapped it around. It's 5148.
5148.
5148.
Okay.
Batch pricing.
I was only told of,
I apologize.
47,
I only
but,
noticed when the chair draws that to my attention. So what we have on slide 53
Yes,
is what
that-
appears at
it's
5148.
much better.
Yes.
Yeah, it's one understands it much better. I
Yes.
think on this one, I'm going to do something on this line that will make sure 3 months from now, if I look at this page, I will
5148
understand
volume,
it
yes,
the way
Chair.
I should understand it.
Yes.
Correct. So,
Okay, but I wanted to say, I wanted to say, saying least acceptable agreement, remove batch pricing, and also having that as the most desirable didn't seem to make sense to me.
correct, Chair, because I think if you understand, this was a template. This was a template, you didn't customize the template for each item, but they adopted a same template. All that they were changing was the Monday that is 6. So in all the worksheets, the headings, most they appear as they are. But I think the message that was being put across here is that under all circumstances, the position must just be one. There's no variance on the position, remove batch pricing. So they just put in under all three items, remove batch pricing. They were consistent, at least in that regard.
Well, I thought that what they meant was their most desirable outcome is remove batch pricing, but that they will not, or maybe I expected that they would not accept batch pricing under any circumstances.
Correct. Correct.
But that can't be correct because they say least acceptable. So which means it's still acceptable. So least acceptable can only, as I understand, can only mean we can live with it, but we don't want it. So, but that's why it's still acceptable, but we'll take it and we'll take it grudgingly, whereas my expectation was that they would say, there is no way we are going to take batch pricing, so remove it. That was my expectation, but my reading of least acceptable agreement, I don't know whether you have the same understanding, is we can agree to it, but we really will be complaining.
But if you look at what is the outcome that they want under the least acceptable agreement, is remove batch pricing.
It's
an unfortunate.
They don't say we don't want it altogether under any circumstances. You understand?
I follow.
It's like it's their bottom line.
Their bottom line is remove batch pricing, because you'll recall.
Or maybe is bottom line the correct word? Maybe it's not the correct word.
Chair, may I perhaps see if we can try and understand that?
Yes.
With reference to another page.
Correct.
You have 5147.
If you look at 5147 as an example, which I say, for one to understand the context of how they use the sheets.
So then if we compare the two, the chair will see that in the shaded areas and what's typed in italics, that appears to be the form, the manner in which the form comes.
Correct.
What is typed in normal font is a response to the respective issues. So if it would appear that every worksheet must indicate a position for the most desirable outcome, least desirable, and the target agreement. So when one looks at 5147, the chair realizes the responses are different. At 5147, the most desirable outcome is no compensation for loss in profits, only 50% of related sunk costs paid for. The second then column says, well, if we cannot get the most desirable outcome, what is the worst case position we can live with? And that now says break pricing as offered by bidders. So there is a difference there. When we go to 5148, our understanding what is sought to be communicated is under any scenario, we will not accept batch pricing. So even if you come out in the least, with a least acceptable agreement, it should not provide for batch pricing. Could have been better, could have communicated the point better, admittedly, but in reading these worksheets, that's the interpretation I think Mr. Sidumedi led us to understand.
My understanding is that what this document sought to do is to give Transnet's negotiating team their mandate for negotiation. Now, when you give somebody a mandate for negotiation, you give them your first prize.
Yes, Chair.
You might give them their second prize, third prize. But one of the things you do is what the bottom line is. And your bottom line might be, if they are not prepared to, for example, remove this item, there'll be no agreement. Okay? That's one position.
Yes.
Another position is you say to your negotiation team, this is my first prize, this is my second prize, this is my third prize. Go and do the best you can. But you know, we can't afford not to have an agreement with these people. I really don't like, I won't be happy if they don't agree to my first prize, my second prize, my third prize. But rather than have no agreement with them, I will take this, but I'll be very unhappy.
Yes, Chair.
We will still have an agreement, but I'll be very unhappy. Now, where it says least acceptable agreement, it seems to me to be saying that we'll still accept an agreement that has got this, but it's the last, it's something that we'll really take with, we'll really be complaining. We don't want. It's just that the alternative of not having an agreement is something we can't afford. So that's my understanding, as opposed to saying, if they insist on batch pricing, there won't be an agreement. That's different. I don't understand that to be what is communicated by least acceptable price or agreement.
Chair.
But it may be that when one reads other documents, then maybe reads them together, one can come to a different understanding.
I guess it will depend, and we'll see if Mr. Sudumedi can assist us with that, whether reference, let's say, to least acceptable agreement relates to the point under consideration or negotiation, or relates to the agreement as a whole. Because if it relates to the agreement as a whole, then this page would communicate, in my view, that when it comes to batch pricing, even the least acceptable agreement will not have batch pricing. The last column says target agreement. What are we targeting agreement to look like in respect of all the various points under negotiation? And insofar as batch pricing is concerned, is the target is the agreement should not have batch pricing. So I say it depends whether agreement refers to agreement on the point or agreement as a document, the contract to be concluded.
And maybe you are in a position to say what your understanding was or what your understanding is of what is being communicated here without what you may have been told during the investigation, but you may have, this may have been clarified during the negotiations by relevant people at Transnet to say, this is what we were communicating. Whether or not we succeeded in articulating it might be another matter.
But maybe let's address in two fronts, Chair. It is this document, on the face of it, before the negotiations were completed, it at least confirms that Transnet, at this stage at least, they were still in, because the reason that they put up this, this was informed by the position in the RFP document, that Transnet does not expect to pay a price premium should there be any reduction in the quantities. And that, as you can see, on that item that the Chair correctly said should be a negotiation position, that the price must remain fixed as if the order is placed for the full 599. So that is consistent with the provisions of the RFP. Now, like Advocate Sello had said, the items on the most desirable, let's compare it with break pricing. On page, and any other one for that matter, can be break pricing or any of the sheets the Chair can look at.
And what was the break pricing now? You know, we have got batch pricing, now break pricing.
Okay. You recall, Chair, yesterday when we...
Mr. Sudumedi, I apologize. Chair, you asked if we were done with volume 2. Perhaps it might be appropriate to go to volume 2 because break pricing at least is specifically dealt with there.
It's okay,
And
I just
then
want to
Volume
understand.
2, and I'll give you a page, and then Mr. Sudumedi can contrast break pricing and batch pricing.
Okay,
Okay.
okay.
Volume 2, Chair. Page 455 2.
455.
4552, it starts, and overleaf, there are 2 bullet points. The second bullet point, specifically relating to break pricing, is at 4553, at the top of the page.
Yes.
So perhaps the chair can read that, and then Mr. Sudumedi will try to distinguish that pricing from batch pricing.
Got it.
Okay, yes.
Okay.
Correct. So, break pricing envisaged the situation we're at during the 7-year program. It was envisaged that the OEMs will deliver the locomotives over a 7-year period, which is why the RFP then made provision for a table for the bidders to indicate, in the event that Transnet opts to terminate the agreement at different stages, what would be the price of a locomotive for each of the break points, if I can use that phrase. Now, those prices, as per the diagram there, it says that was they call break pricing. Because if you look at the column at the bottom, on that table, as an example, Chair, this is a delivery schedule in batches. It indicates different delivery periods, and they inserted different number of locomotives per period, and they're expecting the bidders now to indicate what will be their break price.
For a particular batch, for a particular period.
Correct, Chair.
That's the break price.
That is a break
Thank
pricing.
you. Thank you.
Can I interrogate that a bit? Is it particular price for particular batch, or is it my pricing is based on a 7-year delivery per locomotive? And if after contracting, you then reduce the quantities, because I would have put up my production line to produce, let's say, 599, I'll have certain sunken costs in the first year that I was hoping would get amortized, I'll recover over 7 years. But then if you bring it forward, then I might be saddled with certain costs
Correct.
that I am not able to recover. If that were to happen, you agree that if, according to my bid, I had given you 100 rand per locomotive in the first year and 120 in the second year, over a 7-year period. If you break that, the contract in the third year, I go back and revise my price for first year. It's no longer 100 rand, it's 150. That is the break pricing,
the break
as I
pricing.
understand from
That's
the document. Was that your understanding as
That's
well?
our understanding as well, Chairperson.
So it would be the price that would have been originally given plus whatever extra costs may the bidder would otherwise suffer as a result of no longer having to deliver over a 7-year period.
Correct.
Okay.
And that would happen after the contract has already been concluded. It's quite clear for us
Yes.
to understand
Yes.
this could only arise
Yeah.
in a post-contract award stage. It
Yes.
can be
3
before.
years, 4 years. Yeah.
Okay. Then we go to batch pricing. Now we need to contrast batch pricing with that one.
Correct. So on page 5147, similar template, but this time the negotiating item, not the point. The chess book of the negotiation item is break pricing, right? Reduce risk and cost under breach, and the current offer is a price change due to breach. So that tells you it's a breach of a contract that has been already concluded by Transnet and the OEM. Now, what is a negotiation stance? It says the price remains fixed, no risk of additional cost to Transnet. But then again, just like in batch pricing, the same table, as you can see, they are using the very same template. What's the most desirable outcome? The least acceptable agreement and a target agreement. Now, you see on this one, the most desirable outcome that Transnet would desire, would like to have, is no compensation for loss in profits, only 50% of the related sunk costs paid for. Now, what will be the least acceptable? If you say we have now been unable to achieve that which we desire, is to, it says, break pricing as offered by the bidders. So you see now that is now in line with that example that the chair spoke about, to say there's this range that has been offered to the team to say, this is our target, but in the event that you are not able to reach that target, at least then accept, if you say we have lost on this point, is when you have accepted the break pricing as currently offered by the bidders. Now, Contra distinguishes that with batch pricing. On batch pricing, if you use the same table, the most desirable outcome is to remove batch pricing. Second option, if you say you have lost, still remove batch pricing. So therefore, on this point, it's not an option for you to accept the batch pricing as offered by the bidders. Thou shalt not accept batch pricing. As to whether that will achieve, that's another issue altogether. The point that we tried to demonstrate on this one was that at least that demonstrates that this draft document is consistent with what the RFP had already envisaged. So the drafters were quite alive to the fact that the mandate as per the RFP is that Transnet should not pay a price premium as a result of a reduction in the quantity of the locomotives that are delivered.
Before contract concluded.
Before the contract is being concluded.
Yes.
At page 5147, list acceptable agreement, break pricing as offered by bidders. What do you say that means?
It means, remember, if you compare with, you recall, Chair, on that table that we spoke about?
I want to say, please don't compare it for now. We can compare it later.
No, I'm not comparing it. Our understanding is this, that in the bid documents or submissions, in response to our table that we read earlier on, the bidders have indicated what their prices would be for different stages of Transnet breaking the contract. So there are figures on the table. So the least acceptable means then accept that which the bidders have offered when they submitted their bids.
Yes, you see, that's my own understanding.
Correct.
Too, on that point.
Yes.
And that is why when you go to the slide at 53, I was saying there seems to be a contradiction between saying, when you say the least acceptable agreement is remove batch pricing, because least acceptable seems you will accept, seems to say you will accept grudgingly, but you are saying remove. I think irrespective of what the wording is, maybe one should understand it to be that they actually didn't want batch pricing at all.
Correct.
They might just not have articulated that properly, because maybe in regard to batch pricing, maybe the heading should have been unacceptable agreement. So if you come back to us and say we must accept batch pricing, that's unacceptable, so we won't accept that. you know, because I think that's what it seems they were trying to convey. But when you say list acceptable under 5147,
It makes
on
sense.
the understanding that you give, that I can understand.
Correct.
But I guess that what you are saying is when it comes to batch pricing, your understanding was simply that they were saying that will be unacceptable to have batch pricing.
Correct.
And was that to the extent that if batch pricing was insisted upon by the bidders, there would rather be no agreement?
On this point,
Hmm?
it is on this point, there can never be an agreement. Now, what we would have expected the team to have done then, in the event, as it turned out that obviously there was a pushback on this item, it now speaks to how then do we depart from the provisions of the RFP at this point? Because when the bid was advertised, it was made clear to all the bidders that we reserve the right to split these awards between more OEMs, the effect of which will obviously lead to a reduction in quantities. And in that same table, in page 4552 of volume 2, Transit said it does not expect to pay a price premium should it exercise an option of changing quantities. So that's what was pronounced in the RFP.
Well, I'm not sure what they had in mind, but surely if we have an agreement over a 7-year period, and that agreement entails that from year one, I mean over 7 years, that from year one or year two or whatever, I may start incurring certain costs on the basis that I have a 7-year agreement with you. If I don't incur those costs in the 2nd year or 3rd year, I won't be able to deliver in the 4th year or 5th year. If I incur certain costs in order to ensure that I perform later on in terms of the contract, and then you change the the 5th year or 6th year or 7th year, if I'm obliged to spend money much earlier, but that those costs would otherwise not recover if you change your mind and you terminate on the 3rd year, 4th year, it seems fair that you should compensate me. So I don't know whether they meant that they didn't want to pay even that, or they simply meant to say you don't want you to change the price in terms of getting income. At least the expenses, one would think they should be paid for.
Mr. Chair, that which you have explained is break pricing.
Okay.
Yes, that is break pricing.
That's break price. That's acceptable.
That is acceptable, which is why if you look at page 5147, it does say so.
Okay.
That
okay.
This is what, at least if you negotiate, the most desirable is for us only to be liable for 50% of the sunk costs.
Okay.
That one time was quite alive to
So
that.
batch pricing would be something else.
Batch pricing is something else.
Yeah,
To say before we even conclude the contract, I'm telling you now that you might not get the full 599 or 465. So know now, before we even conclude a contract at this bidding stage, you must know now that you are not going to get the full 599, and you must know that if I decide before award to reduce these quantities, I don't expect as Transnet to pay a premium for that. So that is a pre-contract conclusion position. The break pricing, like the chair has correctly outlined, those costs could only arise during the course of the agreement. So that's a distinction between batch pricing and break pricing.
Well, over the 7-year period, there would be a change in prices for everything, just generally. So the components which you would use in order to build the locomotives, you know, the components would become more expensive each year, you know, 10% higher. I would imagine that that was built in, would have been built into the price.
Correct, Chair.
So what more would they have wanted if they built that into the price?
I beg your pardon, Chair?
What more would the bidders have wanted really if they would have built that into the price? I'm trying to see whether during your investigation you got to understand what it is that they would otherwise have been wanting if they built in the annual increases that would have occurred.
Because, Chair, is quite because those are the issues that were affected in this afternoon session when you speak about escalations and hedging. That's where things like
those
issues would have been built
in.
into the price to look into the duration of the delivery.
Yes.
So all those costs would have been factored in.
Yeah.
As well, them being aware that Transnet is not willing to pay a price premium for a reduction in quantity. So that as well, when they made the offer at the beginning, they would have taken that aspect into account as well.
Yeah. So it's this premium that I'm trying to understand what
they call it a premium. It's a penalty, really, in
it's
effect.
A penalty.
So if you put out a bid for $5.99, and I then split that award between 4 OEMs, it means each OEM, which individually had bid for $5.99, ends up with less, let's say 200. None of them is going to increase the price of the locomotive because now they've got 200 instead of $5.99. That is what we call premium penalty.
Well, maybe penalty explains it better.
The language we're using the language of the RFP.
Okay, all right, thank you. Let's continue.
Okay, so then we understand, and your understanding of the position adopted by Transnet in negotiations regarding batch pricing is important because that goes to certain findings you make.
Correct.
So if you could just very briefly wrap up your understanding and then inform the chair what the eventual position was as regards the batch pricing.
Now, Chair, at the beginning of this slide, I said one of the cost elements that were indicated by Mr. Brian Molefe in his memorandum to the board on why the price increased from the approved 38 billion to 54 with
38 billion to 49 billion.
Correct.
Yeah.
Yes. There are various costs that contributed towards that increase, and an amount of 2.17 billion was dedicated only to batch pricing. And he does even put an explanation there that this is an adjustment of the price as a result of Transnet now having split the bids amongst the 4 OEMs. So as a result of that decision, this is a cost that is attributable to that item, and the total amount of that is 2.7 billion. So we are saying incurring of that cost was contrary to the provisions of the RFP and was thus irregular under the circumstances. So that's the point that we wanted to demonstrate on this issue.
Yes. Just for the record, or in that same response, you said it was a cost of 2.17 billion, then you said 2.7 billion. Can you correct what's the final number?
It's 2.7 billion.
Okay, you had said 17 at some point. Just wanted to make sure that we're on the same page. Okay, then that deals with your slide 3, which is now for the first time we see an introduction of a particular cost that was not contemplated in the RFP. And it, at least the first addition to the original 38.6 billion approved by the board has now increased by 2.7 billion on the basis of this. Is that correct?
That's correct.
So is the position that the negotiation team was given this mandate which on your understanding included that they should not agree to batch pricing, but ultimately they did agree to it, or what happened?
Ultimately, they did agree to it, which is why Mr. Molefe had, in his explanation to the body, itemizes the issues that contributed to the increase in the batch price.
And do we know why they agreed to it in circumstances where their mandate did not include agreeing to it?
Okay. Yes, Chair.
Or am I making you to jump to?
No, I will provide an explanation
Yes.
to the Chair, because obviously, after you recall, Chair, at the beginning of our testimony yesterday, we said the reports were made available to all the persons that were implicated in the reports. So we got various responses. We'll start first with Mr. Chiani and Mr. Lahe. One, they conflated batch pricing with break pricing. In their response, they are saying, no, look at the RFP. Break pricing was envisaged. Break. So in responding to an allegation that the RFP did not envisage a batch pricing,
They respond about break pricing.
they respond about break pricing.
Yes.
So they conflate the concept of break pricing and batch pricing.
But these were senior people who should have known that difference quite well in their own organization. I know that you might not be able to say anything.
No, I fully share the same sentiments, Chair. I think that's which is why in our report we made that point. Secondly, Mr. Lahe.
So in other words, they said, what's wrong with you people? There was nothing wrong that was done here. What was done was envisaged by the RFP.
Correct.
They were talking about break
talking
pricing.
about break pricing.
But I guess that your team would have said, but that's something else. And then what was the explanation when they were confronted with the true meanings of the two concepts?
This is what Mr. Lahe says in writing. We have in our report as well attached the copy of the subsequent email correspondence with Mr. Yusuf Lahe.
Yeah, you may provide Chair with the summary of that response. We'll try and locate the actual response in the meantime.
Later
I still
on,
remember it vividly. He says, this draft document should have been updated because it was now clear after the split that the OEMs were not going to accept to charge a same price that they had offered when the full complement of 599 was offered. So therefore, this, and the ways that he used in that email is that the draft document should have been updated to take into account that point. So he acknowledged the fact that, because at this point, that's where now he sees the difference between batch pricing and break pricing. He said, but this then should not have been a correct position that you should have adopted because the bidders were putting pressure that they want batch pricing. Now, secondly, we then listen to there's a video recording where Mr. Lahe and the team were now briefing Mr. Anoj Singh on the day's and proceedings. Probably on a daily basis, they would have some daily briefings with Mr. Singh to report on what transpired during the day. And this transcript is one of those that will be made available to the Commission as part of our commitment yesterday. In this transcript, when Mr. Lahe reports on various issues, he then says, oh, batch pricing, these OEMs, they got, the way that he used that, they nearly fell off their chairs when we told them that our position is that we don't want batch pricing. The offers must not change depending on the quantities that are being offered. So that now indicates that despite what the subsequent correspondence that it says now that the report is out, at that time when the negotiations were happening, that was a position that he adopted as a transit official. But then, as it is common cause, obviously that position was not successfully advanced. There was a pushback from the OEMs, and eventually they relented. In actual fact, even on that same transcript, Mr. Gianni says, look, you know, that's just a wish. I don't think the OEMs are going to agree to this point.
Who says that?
That's Mr. Tamsang Gianni.
Oh, yes.
Now telling
Mr. Anuj Singh.
telling Mr. Lahe at that time, is this Mr. Lahe that is reporting on that specific item. So the response that comes from Mr. Gianni is that that is a wish, Yusuf. I don't think these guys are going to agree to that point. But at least it confirms the point that the contemporaneous principle that at that time, when the issue was being discussed, at least there was that understanding that batch pricing is something that Transnet doesn't expect to incur. All response that we get now is more of people trying to justify what had happened at the negotiations.
You see, maybe this it demonstrates why we spent a little bit of time trying to understand what least acceptable agreement means.
Yes.
Because when you give a negotiating team a mandate, it's important that they should understand what your bottom line is, what it is that you say. If they don't, the other party doesn't agree to this item, then we will have no deal.
Yeah.
And where you say, look, try and get the best you can, but if you don't get it, don't rock the boat. We must still have an agreement, that kind of thing. But based on what you are saying, it certainly does appear that Mr. Gianni, at least at the time of that meeting, when he said that's just a wish, at least he did not understand the Transnet's position on the batch pricing to be that if there is no agreement from the OEMs, then there would be no deal at all. Okay.
Chair, I've just handed a document to Mr. Sidumedi, extracting it from the volumes. It is from volume 1, page 4318. And I just need Mr. Sidumedi to confirm whether that's the email he just referred to and gave Chair the context. This is a response by Mr. Yusuf Lahe to MNS.
Correct.
As regards these issues.
Correct.
And it would appear to go slightly beyond what Mr. Sidumedi has indicated, because Mr. Lahe justifies the inclusion of the batch price on a decision by the board to include batch pricing of 24 January 2014 at that paragraph 1.
Correct. If as an example, the point that I made, paragraph 8, which appears, first this, like Ritsula said, this is an email from Mr. Yusuf Lahe dated the 14th of August 2018. This was now after he had received the report addressed to Mr. Ndlovu, the chairman of MNS. And the item there speaks to the Transnet 24 locomotives. Now on paragraph 8 of that, after he explains his position about the role that he played, he says, I was never given an approved mandate for the negotiations. Only a draft version was provided. This document that has draft, this now confirms the document that was used. Nevertheless, I acted in good faith to do the best that I could for Transnet. The draft negotiation mandate is surely incorrect and outdated, as the board decision to reduce the batch sizes to 4 OEMs instead of 2 OEMs prior to negotiations was not filtered through into the negotiation mandate. Now, again, in his thinking, the result of the award being split, which eventually led to a reduction in quantities, necessitated Transnet incurring batch pricing. But that is not in line with what the RFP envisaged, because the RFP was clear. If we split and there's a reduction in the quantities, Transnet doesn't expect to pay a price premium stroke penalty should that happen. So this explanation as well does not accord with what is contained in the RFP. He might have very, very good reasons why it made economic sense for bidders to penalize Transnet as a result of the reduction in the quantity, but that is not what Transnet had at least envisaged when it issued that RFP. Because the bulk of his email is dedicated to explaining that rationale of economies of scale.
But isn't the, or shouldn't the position have been that you don't put in a bid if you do not accept that Transnet will not pay any premium if they decide to split the tender, or the, in other words, if in the RFP included that requirement, must the position be that if you submit the bid, it means you accept that requirement? And if you don't accept that requirement, you shouldn't put in a bid. And therefore, why was Transnet even opening negotiations on an issue like that when they had made it clear those who put in a bid must be those who are prepared to accept the terms of the RFP? Did you get to understand any of this during the investigation, why they would they opened discussions with the OEMs on this point?
The consistent theme in our reports on charges relating to procurement is that tenderers prepare their bids in accordance with what is contained in the bid specifications. An organ of state should not be at liberty to materially change the terms of the bid documents during evaluation. So that is the benchmark that we used to assess every conduct that spoke to changes in evaluation criteria. You'll recall, Chairman, on a 95, triple BE became a problem during evaluation, despite the fact of it being a requirement in the RFP. So there seems to have been this approach that we can change the rules of the RFP. It's either people were not fully appreciating the import of what is contained in the RFP when they're evaluating, or some others. One could just not understand on what basis would people just feel the need to change the bids. I mean, even now during the disciplinary proceedings on the same, because it's now one is able to sort of also get a feel of what went through people's minds when these things happened. They seem to be explaining the difficulties that they experienced with the RFP, and now being creative to ameliorate whatever difficulty that they seem to be experiencing, without appreciating the fact that that consideration must take place at the time when the bid specs are prepared. We can't have those noble considerations halfway in the process. So that's an issue that I think the procurement team was failing to grasp.
But do you know whether the bids that were put in by the bidders in response to the RFP, do you know whether those bids contained anything along the lines that I'm not accepting, or we are not accepting this condition or this requirement that there should be no premium. And that is how the issue came to be the subject of negotiation. Or did the bids not raise that issue at all, which might mean they were accepting? And if so, who introduced this for discussion? And under what circumstances when the RFP was clear?
On the first question, Chair, there is no bid that expressly stated a rejection of the transit position on that point. We know that the bids in response, the OEM, made submissions on break pricing, as of course requested by the RFP. So just that part we know. But whatever offer that was on the table at this other stage would have been an offer relating to break pricing. As to who and how the concept of batch pricing arose, Chair, that is not quite clear. Save on this draft worksheet that was produced, and as well a review of that video material where Mr. Lahe was reporting on this point.
It would be interesting to know who introduced it and what was their concern, because if, for example, it was introduced by somebody from within Transnet, one would really want to know why introduce something that's been accepted, because the RFP says here is a tender, you can bid, but these are the conditions. And the bids come in, they accept that condition. There is nobody who makes an issue of it. So how does it come up? And if it is raised by the bidders, at what stage is it raised, and on what justification after they have responded positively to an RFP that makes it clear that this is one of the conditions? Okay.
Yes, Chair, perhaps Mr. Sidumedi might assist us in that regard. Mr. Sidumedi, in your investigations, were you able to determine when the notion of batch pricing first reared its head? Were you able to trace it to its source and time?
The source and time on our investigation is at the negotiation stage. The proof of how it was introduced was this document that we picked up, the draft worksheet that now had a concept called batch pricing. We do not have sight of all, because it's not all the sittings, because we got a couple of recordings of the sittings. So those that we have reviewed, we could not pick this issue out except for that time when Mr. Lahe was now reporting back to Mr. Singh that this issue arose. But again, he doesn't describe who would have raised it, save for noting an expression there that says, when you raise this point, the OEMs nearly fell off their chairs. That's the phrase that he used.
Mm-hmm.
Other than that, one was not able to really pick up who would have initiated the issue.
I don't know if that assists, Chair, but at least we've got a sense that
Yes,
up until
that's
negotiations,
fine.
it was not an issue.
If we are able at some stage to get more particulars on the issue, that would be helpful. Okay. But if we don't, it's okay.
But then referring...
I guess as at some stage when we have got some of the people who were involved in the people who were involved in the negotiations should know
Yes.
who brought this issue up and why.
And the email we referred to, that Mr. Sidumedi referred to, and I gave him a copy, and for the record, it's volume 14318 from Mr. Lahe to MNS, at paragraphs 11 and 12, gives us a sense of what Mr. Lahe's understanding is. And perhaps, Mr. Sidumedi, you might want to read 11 and 12, although I doubt that it would answer the chair's issue fully, but seeing as this is Mr. Lahe's own words, who was part of the negotiating team, let's see how much that may assist.
Correct, because we never had, because at paragraph 11, it just mentions that this was dealt with at some subcommittee. Which one, under what circumstances, we are not privy to, we don't even have the minutes of that subcommittee. So it's just his version of what
Then
might have transpired.
Just read that, the chair doesn't have it open before him.
Page 11.
No, paragraph rather.
So the paragraph 11
Thank you.
of the email reads thus: the batch pricing was accepted by the subcommittee of the steering committee on the basis that the subcommittee of the steering committee accepted the overall price of the locomotive. My understanding being that the subcommittee of the steering committee deemed that they were obtaining value in other areas of the negotiation, e.g. forex hedging, and the subcommittee of the steering committee found the overall price acceptable. Then each item being negotiated was accepted on an overall basis. So that is what, and in the next paragraph, the overall calculation making up the price had to reflect the reality of what was finally accepted by the subcommittee of the steering committee, which includes an element of batch pricing, which contributed towards the price increases. It was common knowledge that this had to be included in the calculations based upon the overall price as accepted by the subcommittee of the steering committee. Had the batch pricing been excluded, it would have been incorrect, as it would have misled the subcommittee of the steering committee of the actual price. In order to provide the subcommittee of the steering committee with the full facts, my calculations had to include the component pricing for each element, of which batch pricing was one of the elements.
That, Chair, then is Mr. Lahe's explanation of how batch pricing came about.
Yes, yes.
I don't know about the Chair. I'm still not quite clear even on Mr. Lahe's explanation, but that is in his own words.
Yes, no. I'm also still not, but I guess that's the best we can do
that's
for
available.
now. Yeah, okay,
Yes,
let's
Chair.
proceed.
Thank you. That then brings to an end our discussion on the inclusion of batch pricing of 2.7 billion.
Just to go back to a point, did you say that in the increase of the price from 38 billion to 49 billion, how much was the percentage that related to batch pricing
The
in
figure
terms of runs?
is 2.7 billion. That is the amount that is attributable to that
Batch pricing.
to batch pricing.
So part of the point you make is that the request for proposals, the tender that was issued, made it clear to those who wanted to submit bids that, in effect, no batch pricing, if you put it that way, will be acceptable.
Correct.
So whoever put in a bid would have to know that that would not be part of the deal.
Correct.
But you say, notwithstanding the fact that the request for proposals made that quite clear, Transnet ultimately accepted a deal which included batch pricing, and that increased the price by at least 2 billion rand.
That's correct, Chair.
And if they had stuck to what the request for proposals had said on this issue, that amount would not have been incurred.
That's correct, Chair.
Thank you.
Thank you, Chair. Proceeding with your presentation, then, we are now at your page 54. and you are expressing your views on the lawfulness of the increase in the final estimated total cost. You may take us through that.
That's right. Just as a context here again on this slide, like I said when we spoke about the previous slide, here you won't necessarily analyze each element. You will recall that there was a memorandum that Mr. Brian Molefe prepared to the board. That memorandum was prepared after the conclusion of the contract at the rate of 49 billion. And in that memorandum, he lists the various issues that caused the increase. So this afternoon, we've also heard the evidence now on to test the justifiability or otherwise of those elements. So in this slide, we are only focusing ourselves on whether in them increasing the original price, did they require to comply with the law? Was there any need for them to get an approval or just report this item to the minister? So the overall conclusion, before you get to us, is that that increase of the ETC was unlawful in that it did not comply with applicable legal prescripts. And the reasons are as follows. You'll recall that in terms of section 54 2D, if
of the PFMA?
Of the Public Finance Management Act, an organ of state or public entity in this regard, before it acquire or dispose of a significant asset, it must obtain the approval of its executive authority. Now, as an entity, if now you want, because the Act does not define what is significant or what significant means. The Treasury Regulations 28, it then provides that the shareholder, minister, and the board, the accounting authority, will then agree on what constitutes significant under the circumstances, and then provide some methodology as to how you determine that figure. If you look at the shareholders' compact that was concluded, and that will then be reduced in what the PFMA envisaged to be a shareholders' compact that is concluded on an annual basis. In terms of the shareholders' compact that was concluded with the shareholder minister, what was considered to be significant was an amount of 3.9 billion. So any transaction to the value of 3.9, it must get the approval of the minister. Because minister must keep tabs, and that's a whole scheme of having an oversight over an organ of state. You need to be appraised as a minister as to the transactions that this entity is concluding, especially if now it reaches the amounts that is agreed on this particular one. So that's what it says on the significance and material framework of Transnet. Now, the ETC, that was...
Sorry, Mr. Stumede, I thought you would address this. You indicated that, and if I misunderstood you, please correct me. Section 54, 2D of the PFMA, read with the MOI, requires that any transaction by Transnet above a certain value requires approval, not up to 3.9.
No, not up to.
Okay.
A transaction of 3.9 billion and above.
And above.
Correct.
That is the one, yes.
Anything that falls below that 3.9, obviously, yes, that's when
yes.
They could transact without the necessity of obtaining an approval from the minister.
Okay.
So that's the context.
Yes, thanks.
And we all know, obviously, that this transaction, when it was initially concluded, indeed, the shareholder minister did approve the amount of 38.9. Now, this transaction, the ETC, amounted to 49. That is an increase of around about 15, if my maths
Over, perhaps?
over. Yeah.
Thereabouts.
It's around about 15. I thought- so that tells us that this transaction, the minister, when he approved on a basis that is the 8.9. To an extent that the increase that occurred now is way above 3.9 billion. It's our view that Transnet ought to have went back to the minister to appraise him of the increase and obtain his approval in that regard. So therefore, on record, you don't have any record of an application being made to the minister for such an increase. So it is on that basis that you are saying that aspect on its own violated the provision of Section 54.2. We are quite aware that in terms of the DOA,
Please indicate what the DOA stands for.
the delegations of authority,
Yes.
it indicates that any in the event that the transaction that was approved and the increase, you want to vary that by 15%, you need to report that transaction to the minister, right? So first there's this compact that speaks of the 3.9 billion. There's a delegation of authority, which is an internal document in Transnet. It's not a document agreed to with the minister that provides that if there's any increase in a transaction that was previously approved, if that increases by 15%, you must report that transaction to the minister. In this instance, even this increase that you speak about far exceeds 15%. So it was not even reported to the minister. So whether you use the DOA in terms of it requiring reporting, or if you align with our view that they were required to obtain an approval based on the compact, neither of the two events occurred, which is why we are saying this increase was not in line with the applicable legal framework.
You then make reference in your slide to ex post facto ratification. Would you like to address yourself to that briefly?
Correct. It's common cause. Like I said, this memorandum happened in May.
So the memorandum by
Mr. Molefe to the board,
yes,
motivating the increase in the ETC.
yes,
The agreements were already concluded in April already
the same year.
of the same year. So the board, upon being presented with the memorandum by Mr. Molefe, indeed approved that increase. So it's our view that an ex post facto ratification by the board does not cure that violation of either Section 54.2 of the PFMA or its own internal delegation of authority that Transnet has provided.
Let me check if I understand you correctly. Are you saying that in terms of Section 54.2, there was an obligation on the management of Transnet or on Transnet to seek the approval of the minister once the price had reached 3.9 billion?
As soon as the increase,
Yeah, the
in
increase.
in the price
Yes,
exceeded at least 3.9 billion,
Yes, yes.
we hold a view
Yeah.
that would have required the triggering of
Yeah.
Section 54.2
Yeah.
D.
But you say they didn't get such approval from the minister. but they did get approval from the board, and you say that approval from the board didn't cure the defect in the sense that, or the breach of Section 554(2) in terms of their failure to obtain the minister's approval. That's the point you make.
That's the point that I wanted to add, that you are making, Chair.
Okay.
Thank you, Chair. Is there anything else you would like to draw the Chair's attention to as regards your findings on this unlawful increase?
That will be our position on that one.
Okay.
Nothing further, Chair.
Thank you, Mr. Stume. You may proceed with your presentation then.
Can I ask in regard to this point of the failure to obtain the minister's approval, what was their response to that point, the management, after they saw that that's what you were thinking, or that's what the report was saying?
Even before during our interview with Mr. Siyabonga Gama, because this is one of the issues, because different persons that we were interviewing were different issues that we wanted them to address. We raised this issue with Mr. Gama. So, Mr. Gama, the increase in the ETC, this is a view that, when did you know about the increase? He said, one, I was not part of the, because I recall, Chair, at that time, Mr. Gama was the GCE at Transnet, but you'll recall that when this happened, he was the chief executive at TFR, not at the office. But this transaction related to his division. So by the time when we interviewed him, he was already now the GCE at Transnet. We raised this issue. He said he only became aware of this increase on that morning when the agreements were already concluded in the morning, because he alleged that he was not part of the negotiations. So he only became aware of the increase when the agreements were already concluded in the morning, and at that time there was a press conference that was already going to be called by the minister to announce the successful conclusion of this transaction. So therefore, he was not privy to the amounts. We then asked, should you not have, now that you are the GC, should you not have, as Transnet that is, have sought the approval of the minister? He agreed with us that indeed we were required as Transnet to obtain that approval. However, at that late stage, he was part of the negotiations. He only learned that morning. It was only a month later when the memorandum was presented by Mr. Molefe, Brian Molefe, that he saw what are the causes. That's when he now was in a better position to understand or be appraised of what led to the increase in the ETC. And besides, by that time, the horse had already bolted. Nothing much could have been done. So that is the position that I know was advanced by the former GCE during our investigations.
And you never got to hear what Mr. Mlefe's position is, because he was no longer at Transnet at the time when you needed comments?
Chair, from my recollection of the reports that one perused, because I think that would have been in response to the Werksman's report, the view that was held by Mr. Molefe was that there was no need for Transnet to obtain further approval from the minister once this was done, because they had already obtained the initial approval when the 38.9 billion was approved. But we never had a direct engagement with this. What I'm saying is purely based on the reports that I've read on this issue.
Who was the leader of the negotiation team?
It was Mr. Anuj Singh and Mr. Tamijiani.
Did they give you any comments on this point? And if so, what did they say?
Mr. Singh, always, you will call, Chair, but was no longer at Transnet.
Yes.
Which is why we asked the GCE,
Yes.
this issue, because we held the view that as a GCE, even as a CE of TFR,
Yes.
because this budget will come from his division. So he's the one that ordinarily would have approved such costs, which is why we had focused our energies on understanding his thought process, because at the end, he's a person accountable for this transaction, at least at the TFR level.
Well, one would have thought that when you are talking such big amounts, no deal would be reached without the CEO of the TFR.
It's TFR.
TFR and the GCEO having been fully briefed what has happened, and with them having said, we have satisfied ourselves that everything is in order before the negotiating team could go back and say, okay, we have a deal. You didn't get a sense that that happened, or you did get the sense, or what was the position?
The sense that we got, and especially as confirmed by the response by Mr. Gama, is that the negotiating team were in some premises, because on that day, the meeting, I know it was at some hotel, as he mentioned, even though he couldn't provide us with the name of the hotel, when the transaction was concluded. But from the look of things, Mr. Brian Molefe, who was at that time the GCE, was obviously aware of the increase, because he, Mr. Gama, he directed that question to Mr. Molefe to say, what is the final figure? Mr. Molefe, Brian Molefe said is 149. In his words, he said he was actually shocked by
that is Mr. Gama.
That is Mr. Gama.
Yes.
He was shocked to hear that figure. In actual fact, on that day, he was in the company of the chairperson of the board, Mr. Mkonas. He conferred with Mr. Mkonas. Do you hear what Mr. Brian Molefe is saying? We'll see how we'll deal with this issue. Because at that time, from our understanding, at least when we interviewed him, was that there was a press conference that was about to happen in a matter of minutes, and the minister was also aware of this new amount, and now they were going to announce that
The deal had been concluded.
yes, at that time, the agreements were signed already. So, which is why there's a press conference to announce that we have now successfully concluded one of the biggest locomotive transaction that's going to have all these benefits for the country, and so forth and so forth. So that's the context that we understood from Mr. Gama, at least when we interviewed him on this aspect.
Well, certainly, I think the GCEO, GCE, should really look at a contract like this before it's signed, when there are such big amounts involved, and certainly also the CEO of the unit concerned. But we will hear from them. Yes.
Thank you, Chair. And just to place on record, the summary of your discussions with Mr. Gama in this respect will be found in the transcript.
They are in a transcript
that you'll be providing. Thank you. Now, the chair asked you about Mr. Gama's understanding and the position he took, and you provided an explanation. I would like to refer you back to Mr. Laher's email, volume 1, page 4318, that you dealt with earlier. And I would like you to have regard to paragraph 16, because paragraph 16 appears to give an indication of an appreciation of the increase in the ETC and how that issue was dealt with before the contracts were concluded.
Correct.
Yes.
Let me just give you context to, let's read the paragraph before I give the context. Mr. Lysis?
Please don't forget what the question was.
I know the question.
Yes. At some stage, I would like somebody to read section 54.2 to me. At some stage, number one. Number two, I would like to know who were members of the negotiating team, but that I can be told now or later. I'm easy. You are ready to read 54.2. Okay, just read it. Yeah. Okay.
The heading of Section 54 is information to be submitted by accounting authorities, being the boards. Before a public entity concludes any of the following transactions, the accounting authority for the public entity must promptly and in writing inform the relevant treasury of the transaction and submit relevant particulars of the transaction to its executive authority for approval of the transaction. It lists various transactions of this nature. The relevant one for this purpose is D, being acquisition or disposal of a significant asset. So that's what Section 54 2D reads.
And you said there is no definition of significant.
And then if you refer back, Chair, to Regulation 28.3,
yes,
Treasury Regulation 28.3 of the PFMA.
But just to complete, in the Act, there is no definition.
In the Act itself, there's no definition.
Okay, all right.
And that is expected because those will vary from time to time. For purpose of material, in brackets say Section 55.2 of the Act, and significant, in brackets for Section 54.2 of the Act, the accounting authority must develop and agree a framework of acceptable levels of materiality and significance with the relevant executive authority. So that will be now an agreed framework between the board, being the accounting authority, and executive authority.
The minister.
And being the minister. And we know
Yes.
that this is on an annual basis.
Yes.
If you go to the Assurance Compact, this aspect will be addressed to say,
Yeah.
for the purpose of this financial year,
Yeah.
these are the assets, X percentage of these assets constitute a material framework, so it is this transaction then
Yes.
of this value that
Yes.
must then be reportable. Because in the practice notes, then they will flesh out how then you go about agreeing the framework between the minister and the board.
Yes. So each year, the executive authority and the accounting authority are supposed to agree how they will understand significant materiality to mean in terms of Section 54.2 read with the regulations.
Correct, Chair, because the guidelines issued by Treasury in terms of calculating what is significant and material speaks to the total assets
Yes.
of the entity. So
Yes.
to an extent that there will be increase of that will require a revision of the actual amounts, which is why
Yes.
the compact, even though the compact doesn't necessarily deal only with this aspect, because there are other issues that are contained in the Assurance Compact, but it's one of the items in the Assurance Compact is this aspect, this issue.
And you say that for the relevant period, in this case, the amount in the increase of the price that would trigger that provision was 3.9 billion.
Correct, Chair.
Okay, all right, thank you.
Thank you, Chair. And perhaps for reference purposes, that shareholder compact is part of the exhibits to be found at volume 3, page 4980, and that will give us the trigger threshold of 3.9 billion. Thank you, Chair. Getting back to the question, Mr. Sidumedi,
Correct.
you were going to explain to us, or at least highlight to us, Mr. Lahaye's understanding regarding the increase and what steps he took when he realized that the ETC would be increased. And you do so with reference to Mr. Lahaye's email at page 4138, volume 1.
Correct. Let me read paragraph 16 before I provide the context here.
Yes.
Nevertheless, I acted in good faith to the best that could be done for Transnet, and together with Mr. Danny Smith, we advised the GCFO, Mr. Singh, that the transaction is exceeding ETC prior to conclusion of the contracts. The GCFO said that he would deal with it. The reason Mr. Lahe sent us this email is that during our investigation, we came across a document prepared by him and Mr. Danny Smith. The document did not have a date. It just said April 2013. 2014, my apologies. In a document, he was explaining the reasons for the increase and saying this increase or this amount that we are about to, or this amount that we have now agreed on exceeds the ETC that was approved. We need to get approval from the board. That's what the gist of the memorandum was saying. Now, in our plenary report that we produced in June, we had said, because we were at a stage we were not yet interviewed Mr. Lahe, we said, we picked up this document. We don't know whether it was prepared before or after the negotiations. So we need to inquire, before we take any action against Mr. Lahe, we first need to inquire to determine his capability. We need to inquire whether was this done before or after. So that's the note that was in the report which he got. Which is why now you have provided an explanation to us to say, no, that document which we have accepted, it was not dated, it's in April, but we prepared it with Mr. Smith prior to the conclusion of the contract. But the CFO, Mr. Singh, had said, don't submit that document, I will deal with the issue of the increase. Which is why, in response to this, when we now finalized our report, we then did not make any finding against Mr. Lahe, at least on this aspect.
And this you do, I'll rephrase. As you indicated to the chair, Mr. Singh is not one of the people you had the benefit to interview.
No, we never interviewed Mr. Singh.
Thank you. Then if the chair is clarified on the issue of increase of the ETC, we may proceed with your presentation.
The next part of the presentation, Chair, speaks to, you recall in our mandate, we required to establish if indeed there was a relationship between Tequesta and CSR. So in this part of the slides, we'll be focusing on that item. But before we deal with that particular specific agreement, it is prudent that we first outline the relationship between Mr. Iqbal Sharma and Mr. Salim Issa.
And this you do because understanding that relationship is relevant to the question of the agreement with
And the
Tequesta.
agreement and the findings that you have made around that agreement. This diagram indicates that we start with a company called Ilgasolv on top. Mr. Sharma declared at Transnet on the 28th of February 2018 that he has 50% shareholdership in a company called Ilgasolv. And when you conduct the CIPC record, it confirms that Mr. Salim Issa was a director in that company. So this now we know the first link, that there's a business relationship there. At the bottom,
Sorry?
It's a pity I can't.
Okay, now it's at bottom, you say, is it bottom sentence, bottom block, box?
There's a top block that says Ilgasolv,
Yes.
which I've just spoken about now.
Yes.
Ilgasolv owns 80% shares in a company called, if you go to the left, NADP.
Yes.
And the directors of NADP is Mr. Iqbal Sharma and Mr. Issa.
Yes.
There's a second link. In turn, NADP, 20% shares in NADP are held by a company called ISA Capital, Pty Limited. And Mr. Iqbal Sharma was a director in ISA Capital.
Yes.
So it confirms that at least insofar as Eagle NADP, and ISA Capital, Mr. Sharma and Mr. Salim Issa have business interests in varying degrees, of course. And as well, ISA Capital owns a company called VR Laser Properties, towards your right, which is owned by Mr. Iqbal Sharma. He was a director he was a director in that company from 9 December 2012 to 12 October 2015, according to the SABC records.
I think that's 2013?
It's 2013 to 2015.
Yes. That's well.
VR Laser has leased premises to a company called VR Laser Services, in which Mr. Salim Issa is a director. In turn, that VR Laser, 79% of its shares are held by Ilgasolv, whereat both Mr. Salim Issa and Mr. Iqbal Sham have a stake. So there's that relationship that we wanted to at least outline, so as to understand some of the conclusions that we reach later on in our slides.
Okay.
The next slide just outlines the role of Mr. Iqbal Sharma within Transnet. We know that he was a board member in 2010 to 2014. He was also the chairperson of the BADC. I remember the BADC between 2012 and 2014. And on 24 January 2014, this BADC, which was chaired by Mr. Iqbal Sharma at that time, approved the award of the 24 locomotive transaction to Bombardier, CNR, and CSR. CNR, CSR, and GE. So we know that at that time, when the award took place, the chairperson of that committee was Mr. Iqbal Sharma.
Okay.
So that is the context that we thought the chairperson must have as we are proceeding with the next slide.
And before you leave that slide, I note you indicate that based on that decision by BEDEC,
Correct.
BT were allocated 240 electric locomotives, CNR 232, CSR diesel, CSR 359 electric, and GE 233 diesel. I note at your page 57 at the bottom.
Yes, that's CNR electric. One of them should add. The two are electric and the other two are diesels.
The 232 awarded to CNR are electric.
Correct.
So there is an error there. So instead of 232 diesel to CNR, it should read 232 electric.
Correct.
You sure about that? Yeah.
Yes, sir.
Okay. And
All these corrections that need to be made.
they will be followed by a statement, Chair.
Okay.
It just that it's important that this correction be noted at this juncture, because the number of locomotives find their way into the agreement that Mr. Sidumedi will be dealing with, and to avoid confusion.
So 232 becomes
Electric. It is wrongly defined in the
as diesel.
as diesel. It's two electric locomotives. Is it correct? That's why, Mr. Sudimeti?
Correct.
Which would mean the CSR 3559 are diesel.
Correct.
No. Are you getting it right?
Have you
Can
got
you
it
just
right?
get that thing right, Chair?
Just get me there.
The 59 must be electric. The 59 is electric.
Which is CSR.
Let me just confirm that. I know CSR got.
Okay, let's do this, Mr. Sudimeti. Let's proceed. Ms. Mulefe will find the award document, and then we can place on record that correction, of course, to be subsequently followed by a statement regarding all the corrections you have made to your slides.
Correct.
So in the interim then, let's proceed to your page 58.
Now, on page 58, we deal with the business development agreement that was concluded between CSR and a company called Tequesta. Tequesta, the agreement is found in volume 3,
Yes.